Office of the Attorney General has rejected claims of bias, procedural irregularities and constitutional breaches in the ongoing impeachment probe of suspended Chief Justice Gertrude Torkonoo as he opposes a motion filed by Justice Gertrude Torkonoo seeking to halt the ongoing proceedings. The suspended Chief Justice yesterday, May 26, 2025, filed the injunction application alleging that the proceedings are a mockery of justice and a ruse of unjustifiable to remove her. She said her rights are being abused by members of the committee probing the 3 petitions for her removal, and she's not even sure whether there are 5 petitions or 3. Let me read to you excerpts of what she's filed in court, and I'm quoting, that I respectfully seek leave of this honorable court to bring to the court's attention various developments since the filing of the present application which evidence a complete desecration of my basic constitutional rights to a fair trial, violation of my dignity and subjection to inhuman and degrading treatment of a kind not meted out to even accuse persons on trial for treason and other offenses against the state. That other developments like the denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephones and laptops for myself and my lawyers, even though counsel for petitioners have access to their phones and laptops, and the conduct of the hearing itself in a high security zone at the premises of the Castle Osu show a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental human rights. That all Article 146 proceedings, with the exception of the one I am being subjected to, had hitherto been held in a judiciary facility, especially the courts complex. The location of the proceedings affecting me to a cordon high security facility boggles the mind, unquote. So these are excerpts of what the suspended Chief Justice has filed in court. Now she wants the process to be halted and also the committee dissolved. But the Office of the Attorney General has, in a swift response in an affidavit in opposition to the injunction application, rejected the suspended Chief Justice's claim that she was not informed of the reasons behind the prima facie determination. The Attorney General's office argued that Justice Torkonoo followed an improper procedure in her attempt to obtain those documents by filing an injunction application. The AG's office has also objected to a request to have members of the committee barred from hearing the applications related to her removal. The AG defended the decision to hold in-camera proceedings, describing it as, quote, constitutional command designed to protect not only the suspended Chief Justice, but the entire judiciary, adding that it cannot be waived, unquote. The AG went ahead to say that he is also dismissing calls for the 2 Supreme Court judges sitting on the investigative committee to recuse themselves over allegations of impartiality. Now, specifically on Justice Samuel Adibwe-Siedu, the AG clarified that he did not participate in the injunction hearing brought by one of the petitioners and therefore cannot be disqualified. For Justice Gabriel Scott Poaman, the AG also argued that his involvement is unrelated legal matters involving one petitioner does not constitute evidence of bias. The Attorney General maintained that no legal basis exists for the injunction being sought by the Chief Justice herself for the court to stop the process, and thus praised the Apex Court to dismiss the application. The application is expected to be moved tomorrow. Let's go to Zoom and speak to a private legal practitioner, Lawyer Theophilus Jemega Jr. Counsel, good evening to you. Thank you very much for your time on 505 this evening.
Good evening, Val. Can you hear me?
I can hear you loud and clear.
Good.
This matter seems to be getting interesting. Now, this is the Chief Justice suspended who has raised a lot of issues. Now, she says that there is a complete desecration of her basic constitutional right to a fair trial, a violation of her dignity and subjection to inhuman and degrading treatment of a kind that even people who have been accused of treason and other offenses against the state are not being subjected to. For a suspended Chief Justice to raise this? This is a very serious matter, isn't it?
Yeah, good evening to your listeners. Wow. The good thing about affidavit in support or affidavit generally is that it tells only one side of the story. If you match the affidavit in support together with the affidavit in opposition by the Attorney General, you will come to a different conclusion. And that is why we have the arbiters, the judges, to look into it, to be able to say, this doesn't seem right. In any case, let us quickly go back. In 2020, during the election petition.
Counsel, before you continue, can you please reposition your camera? Because they said they can't see. Okay,
sorry,
fantastic.
I thought,
fantastic.
Okay,
now you can see. Great.
Good. So in during the last election petition hearing, this same suspended CJ gave orders that even lawyers are to be searched before they enter the Supreme Court building. So what has changed? So if lawyers were being searched then before they enter the Supreme Court building, what has changed that they are searching her? I believe that when they conduct search on her, that search will be done such that there will not be any intrusion into her privacy. Such a search will be conducted by a female, not by a male. In any case, what is the purpose for the search to be conducted? If you read Article 146, again, the provision that talks about in camera, you will see that the in camera is italicized. Look at it again. That part is italicized. I don't know which other part of the Constitution has such an italic in it. So such a thing should tell us that the framers of the Constitution attach great importance to that. So the basic right to fair hearing is fair trial is they hear your side, they make adequate provision for you to be heard. Is the Chief Justice saying that by virtue of the fact that a search is conducted on her body, one, the policy rationale is to determine whether there are recording devices for her, on her. Number two, it could be a situation where there could be weapons. Look, it's only in this part of the world that you walk into every office, every court, every trial, and searches are not conducted. Until recently, when you get to Supreme Court, it is done for the public. Even if you get to the court complex in Accra, there are searches being conducted. We have a machine there. So what is she talking about that her right to fair trial is being violated? Now, her right to dignity, I don't think is being violated. Number two, she said that the choice of the venue, hitherto, the choice of the venue
would have been the judiciary,
the court complex. Yes, but we've not had a situation where a Chief Justice has been asked to come for hearing. We've never had such a thing. So that argument doesn't hold. If she's talking about other justices of the Superior Court, this is a sui generis. It's on its own. It doesn't correspond to the ones we have seen before. And you see, again, when you compare with what the Attorney General has deposed to, the policy rationale for the in-camera, it's not only to protect the person coming to the committee, it's also to protect other members of the committee, witnesses, the panel members, etc. They are supposed to be protected. Granted that even the Chief Justice has a right to say, I waive
she waives
my right
off her
to,
right, yes, for the in-camera
hearing in camera. Does it mean that the others will have to cover their faces or speak behind barricades or speak behind something that will block their faces that you don't see them? That cannot be done. And it is not a situation where you choose one way or the other. I pray that tomorrow this issue is determined and we see the way forward. But I don't want to preempt some of these things. But what is it that has been argued over and over that will be argued differently tomorrow? That has not been argued in at least 3 of the cases that have been heard so far.
No, but this one, she says that she has been denied access to telephone and even laptop for herself and her lawyers. But the counsel for the petitioners have access to their phones and their laptops. So this is unfair.
Yes, unfortunately we have not. If you look, the Attorney General has denied most of those amendments. But we have not had a situation where the petitioners' lawyers will also depose to affidavit to say that this is what has happened and that has not happened. So tomorrow at the trial, the judges will have the opportunity to ask questions regarding some of these things. And if it is true and what is the rationale for taking a laptop in? I would have thought that the Chief Justice should have stopped to ask questions. Why is it that they prevented my husband and my daughter, as she said, from entering? Again, we are talking about in-camera hearing, and this has been the justice of until her suspension. Paragraph 1, unfortunately, did not say I am a citizen of Ghana and the suspended Chief Justice. It says I'm the citizen of Ghana and the Chief Justice, because we have an acting Chief Justice as well. This is somebody who has been at the head of the judiciary, someone who is an epitome or supposed to be the one who understands all our laws, and all our laws are in her bosom. She shouldn't fall to such very, very small issues. I said on a sister platform, all this to and fro that we are going through, perhaps it's only to delay the process. But let us mimic her words, which she has said. Despite all the noise, the law is the law. Let us go on with this procedure. If she is exonerated, she comes back. But all this dilly-dallying and dangling is delaying the process. But again, I don't think, where I stand, what we know in fair hearing, she's been accorded everything. Then she's also asking for the reasons for the determination of the prima facie case. You see, it is not a trial, that you say that, let me see the reasons you have adduced. Why? Because you have A, B, C. No. The prima facie case is only to look at, does the person have a question to answer? That's the question you ask yourself. And you say, yes, the petition that you did is, you have a question to answer. That's all. What else are we talking about that she needs to be afforded?
Because she says she wants to respond to the petitions. Initially, she was told that there were 3 petitions. Now we know there are 5. So maybe in her response to the president, when the petitions were forwarded to her earlier, there were 3 petitions that were forwarded. She responded to the 3 and is left with 2.
No, Val, looking at how critical and how important this issue is, I don't think that if the last 2 were received and they are being dealt with now, they wouldn't have given it to her for her to comment on. She would definitely have had the opportunity to comment on. Look, let's give a bit of credit to His Excellency the President and the council around him. He's not working in vacuum. And this is an uncharted waters. We have not been here before, at least in our recent history, jurisprudential history. We've not been here. So the president cannot just pick and choose and do things without following due process and without following sound legal advice. Let's give them that credit. Okay. So I don't think that 3 petitions would have given to her, she would have answered, and the last 2, they would have said that, okay, we will not give you the last 2, so let's go on and use all the 5 in an important situation. That would not have happened. Definitely, she would have been given, assuming they are using the last 2, they would have given her the opportunity to respond to the last 2 as well.
So, based on what the Supreme Court will decide tomorrow, how will the Chief Justice demeanor be before a committee that she has issues with all 5, and now in the latest injunction she names 2. She says Justice Samuel Adibwesiedu and Gabriel Swart Paman should not be included because she has issues, although the Attorney General has responded to these issues.
Well, before the first petition that was filed by Vincent had Asiedu on it. And Asiedu was appointed to be on this committee.
Yes.
So Asiedu never sat on the panel that determined that case. So I don't know where this is coming from. In any case, let us just remind the Chief Justice. Recently, I think it's one of the issues in the petition that at a stage where a panel was constituted to hear a case, they began the hearing and she changed the panel.
It hasn't happened just once, or at least there are 3 cases that people raised issues about.
Yes. So then, when it was good for you, it was called a bed. Today, that is not good for you. You are referring to it as a vulture? No. The same yardstick you used then, allow the yardstick to be used for you. You see, people who have fallen victims to some of these things will be laughing and be like, what is this lady talking about? And what is her lawyers up to? Then he was saying that Justice Scott Waman was also a member of a panel that ruled when one of the petitioners had a case in the Supreme Court. And so what? It is not the justice's case. You ask what to be her demeanor. The last time I gave you a scenario, perhaps let me quickly recap. In 1981-82, when PMP took over office, Justice Apalo was the Chief Justice. Then the PMP members who were majority in Parliament said he should come for vetting. Because, and you know, they were doing it because Apalo was member of the committee that investigated Kwame Nkrumah. And PMP was the offshoot of Nkrumah. Then the judiciary somehow, when the case went to court, protected Justice Apalo. And that was the Tufo versus Attorney General case. All lawyers know. Fast forward, we had that of Justice Abang, when GBA went to court to say, remove him because he's not a person of high moral character. Judges wrote and said, we wanted to remove this guy through a wrong means, go and use the appropriate means. They never came back. Justice Akwa's one came. Then you saw how the judges wrote about the in-camera. That's the Ajechum case we have been referring to. But pay attention to the current one. The cases are being lost 4-1, 4-1, 4-1. You see, when you smell the coffee.
As a first was 3-2.
3-2. Okay. When you smell the coffee, you must know the type of breakfast you are being served. So the question you ask about the demeanor, see, this to and fro is already causing a bit of friction. Or, I mean, we are human beings. It will be causing a bit of disaffection, if I use it loosely, or a bit of non-unity within the judges. Assuming she is exonerated, would she be willing and freely and open heart be able to empanel those judges and say, let us work together in certain cases? That will be difficult. So in order to not to bring all these justices in, out, I believe that she should allow the process to go on. In any case, so far, everybody that is talking about this process has not been able to cite one single infraction that is unconstitutional or unlawful to the whole process. And the process has been moving on. So I think that she should rather abandon some of these interlocutory applications, not injunction, interlocutory issues, and let us deal with the substantive issue. Okay. And I want to put on record that NDC has no interest in her removal, which is an exonerated. NDC will work with her.
Okay. Counsel, there's a piece that has been written by Professor Bafo Ajimendua, who is a former United Nations senior governance advisor. Now, in his write-up, he's saying, and I'm quoting, the alleged breaches and betrayal of the office by the Chief Justice Torkonoo could be serious matter, but it would be imprudent to simply personalize and hurriedly get rid of her. The problem is much bigger than the individual, and it has far-reaching consequences. It goes to the foundational democratic principles of checks and balances, which is built on the notions of separation of powers and the independence of the three key arms of government, that's the judiciary, parliament, and also the executive. He goes on to say the problem, therefore, is not whether to condone a chief justice or court that goes rogue, but how and by what means the mischiefs is cured without damaging the sanctity of the principles and the notions. He says President Mahama chose to do what the Constitution requires of him, and he cannot be faulted. However, he has unwittingly followed his predecessor. I mean, he's talking about former President Akufo-Addo, unprecedented act of removing the Electoral Commission chair, Charlotte Osei, in 2018. Should Gertrude Torkonoo's ouster come to pass, it could introduce a trend where a president, based on petitions against dislikable heads of independent democratic institutions, would trigger their removal. We must urgently stop the emerging cycle of incoming governments pledging and indeed proceeding to replace the heads of government institutions, as both the NPP and NDC have done it. A sustainable cure is to take the executive out of the affairs of institutions. Equally urgent is to curtail the ease with which citizens trigger presidential actions on matters as ponderous as the removal of the heads of these institutions. For example, petitions should be given weight by requiring a specific number of signatures of citizens to indicate widespread support. Because to him, if individuals dislike one person who is a head of a government institution, once a new government comes into power, people will petition the government and then they will trigger a process to remove it. But if we do like a specified number of people who can sign a petition that will trigger that, then we are moving forward. Then he's also saying that we should look at the Kenyan example, where again the Judicial Council, through well-defined processes, can recruit, appoint and remove justices of the court. He says the model takes out politics, promotes meritocracy and fortifies institutional independence. Now he's talking about, yes, President Mahama might not have done anything wrong going by the constitution, but he's seeking to set a precedent, just like has been set in the Charlotte Osei case, to also remove the Chief Justice. So we should just, maybe the Chief Justice did something, we should not simply personalize it, but we should look at the position she's occupying, because this is going to serve as a pathway for us. What do you think about his position?
It's an unfortunate write-up.
Really?
Unfortunate in the sense that, can you hear me?
Yes, I can hear you.
Yeah, I said it's very unfortunate write-up.
Why?
Unfortunate in the sense that, one, I don't think he knows the history of our constitutional democracy. And I've just told you the history of our constitutional democracy, where there had been attempts to remove CJs and they had failed. So that if he should marry that onto his write-up, you will find out that his write-up does not take into consideration our history. Now, number two, his write-up looks so sweet and so good. Won't it be okay for him to go and meet the Constitutional Review Committee and put this write-up before them, so that they will factor that into their report? Number three, he talked about the fact that signatories, how are we going to do the signatories? By online. Current situation where we have, you can use AI, etc. You can even go to a village secondary school and say, I am doing this. Everybody just
come and
sign this petition for me. You could get that. It won't cure anything. Number four, he said that parties pledge and carry it out. For example, the removal of independent officers. NDC never pledged to remove the current suspended CJ. NDC JM rather said that he hopes that with her introduction, things will be better. And let me put on record, during her vetting, she enjoyed bipartisan approval. That was when we even have the knife edge 136, 137. So you can't liken that to a situation where NDC wanted her out. Finally, he was also talking that the thing is not about a personalized situation, far from the truth. Anybody who is at the office of such a person is a person. We are not talking about the office. Read again the reasons why you can remove the CJ: infirmity of the body and mind, stated misbehavior, and inability to work. Are we talking about the office having a stated misbehavior? No, we are talking about the occupants of the person of the office having a stated misbehavior. We're talking about the office being having infirmity of body and mind. No, we are talking about the person who is occupying. You know, again, let's go back to our history. We have had situations. I gave you that of Apalu, that culminated in 24 versus Attorney General. I gave you that of Aban, that was GBA versus Aban. I gave you that of Aqua, which was the Ajay case. In all these situations, the Supreme Court stood up and protected the office of the Chief Justice. And I believe currently they are standing up to protect the office of the Chief Justice. Unfortunately, however, currently the protection is negative towards the occupant of the office of the Chief Justice. So for a very good professor to have written this article, well, it's quite good. I just Googled it. I've seen the article. I'll take time and read more. But I think that it will serve a better good for Ghana if he directs that Constitutional Review Committee.
Council, very grateful for your time. We'll let you go. I'm sure tomorrow we'll speak to you again.
Val, before I go, my younger brother is celebrating his birthday.
Wow.
Nat, you are listening to me. Natty boy,